Hello everyone. I hope this message finds you fit and fine. In our journey of Indian Constitution, we were discussing fundamental rights. And within that, today we need to talk about cultural and educational rights as mentioned in Article 29, Article 30. Thereafter, we are going to discuss right to property, its status, then Article 31A, 31B, 31C in a simple manner. We are going to do operation on these provisions so that those details are visible to you on which questions are asked in exam. So two aspects, culture and education, and these rights are available only to citizens. This is one statement which can be asked. Now take a look over the title, the language which is used. Protection of interest of minorities, that is Article 29. So word minority is used in Article 29, okay? But that does not mean that our Constitution defines the criteria on which minority status will be given. Although two types of minorities are recognized in our Constitution within these set of rights. One are religious minority and other are linguistic minority. Okay. So now we have two clauses within that, 29 subclause 1. So it talks about your right to conserve your language, script and culture. Okay. So this right is a right given to group. Okay. Because a group will have a language, a group will have a script, a group will have a culture. Right. Now, but when it comes to 29 subclause 2, this right is available to you as an individual. Okay. No discrimination in education institution. My friends, Article 29 subclause 2 is not talking about minority institutions. Please keep this in mind. Some students actually link it like this, that since the title itself was saying protection of interest of minorities and subclause 2 is talking about no discrimination in education institutions. So they actually mix things up. But you should read it separately. Okay. So it says that no discrimination will happen with you on the basis of religion, race, caste and language, any of them, in an educational institution maintained by the state or receiving aid out of state funds. Okay. So this particular right, subclause 2, is available to you as individual, and these LSC, language, script, culture, so these are available to you as group. Okay, these kind of statements are made. Now, if I ask, can rights mentioned under Article 29 be accessed by people other than minorities? Now, what would be your response? Some of you would say, sir, what kind of question you are asking? It is quite common. It's obvious. Since the word is minority, it means only minorities will be able to access the rights mentioned under Article 29 subclause 1, subclause B, right? That is what you were thinking. But my friends, that's not true. Because Supreme Court has interpreted this provision in a different manner. And I'm also going to tell you what the reason was. So first of all, Article 29 grants this right to minorities on the basis of religion and language. I've already told you, two kinds of minorities are mentioned. Okay. So there was a debate that whether these rights to preserve language, culture, script are available only to minorities. What if some other people who are in majority, they want to take actions for preserving their script, and if any government authority is restricting them to actually take some steps to conserve their script, language or culture, can they knock the doors of Supreme Court using Article 29? So some scholars were saying, legal luminaries were saying, no, Article 29 subclause 1, subclause 2 won't be available to people from majority, because majorities won't need to conserve their language, script, culture. This need is only to the minorities. But as this debate was going on, and when this debate reached Supreme Court interpreted in a very beautiful manner. What Supreme Court said, the scope of this article is not necessarily restricted to minorities only. Okay? It is commonly assumed to be, since you read this title of Article 29, minorities mentioned. That is why you assume that. Sections of citizen word is used in the language of these clauses. Take a look. Article 29 title says Constitution of India, protection of interest of minorities. But when you read this language in subclause 1, it says any section of these citizens. So now Supreme Court said, since it is saying any section of citizens, it means it is available to every section of citizen, right? Residing in the territory of India or any part thereof, having a distinct language, script, culture. 3 things, LSC. Its own shall have the right to conserve the same. So on the basis of this, now Supreme Court has interpreted this is not restricted to minorities only. This can be a statement in your exam, and many students will fall into this trap. Okay, but you are not going to do. Now, no citizen, subclause 2, which is available to you as individual. It says no citizen. It's not saying no citizens who are minority. Okay, shall be denied admission into any education institution. Any education institution, I told you it is not talking about minority education institutions because that is mentioned in Article 30, not 29. Maintained by the state or receiving aid of the state funds on grounds only. Now grounds, on grounds questions are asked. Religion, race, caste, language or any of them. My friends, there are 4 grounds mentioned here. 4 grounds only. Okay. Now, I hope now this is clear to you. Right to conserve the language includes right to agitate. For example, if government authorities, state is not taking enough actions to preserve, or you can say conserve your language, script and culture, and you want due efforts to be made, then you can agitate. And this right to agitate can also be considered under the definition or interpretation of Article 29. But this agitation is specifically for conservation of LSC. Okay? Please remember it, because if a statement is made in this manner that a right to agitate can be inferred through the interpretation of Article 29. So some students might think, oh, it should not come here. It should be related to Article 19. Okay, these kind of traps are leveled. Okay, but I hope now you are clear. It is interpreted in this context. Now, take this question. Article 29 subclause 2 protects from discrimination on the basis of, because basis is mentioned in subclause 2, which is available to you as individual. So what bases are mentioned? 4 bases I have just told you. 4 grounds. Come on. Religion, caste, race and language. Now take a look in which option these 4 are mentioned. I hope it is quite visible to you. So this is the answer. Okay. Be prepared for such question, and the best way to remember these grounds is make a mnemonic. Okay. Mnemonic means some code. Okay. RRCL, right? And within R have this differentiation. Okay. RR means religion and race. Now, there's a difference between Article 15 subclause 1 and Article 29 subclause 2, because both, why there are similarities? Because both talk about discrimination. Okay. But there's a difference on the kind of discrimination and the grounds of discrimination. Protects rights only against the state. Subclause 1 I am saying. 15 subclause 1, we discussed it. Subclause 2 and on, they talk about state as well as private individual. But subclause 1 of Article 15 talks about only state. Right? Protect right against state and other institutions as well. Okay? Prohibits many type of discrimination in Article 15 subclause 1. Right? But in this case, it is talking about admission into means special actions like admission into education institution, because word education institution is specifically mentioned in Article 29 subclause 2. And why? Because the kind of rights we were talking about are cultural and educational rights, right? Cultural aspects I have mentioned in Article 29 subclause 1, LSC, language, script, culture, and educational rights are mentioned in Article 29 subclause 2, and other educational rights with regard to minorities are going to mention in Article 30. We are going to talk about it. Now, this clause covers a wider area, and it is applicable on all citizens irrespective of minority or majority. Now, only relate to admission into education institutions maintained by state or receiving aid out of state funds. And this is applicable also on minority as well as majority. Please remember that, because this is a trap which UPSC is going to ask. Prohibits discrimination on the basis of sex and birthplace also, because Article 15 mentions what? What are the grounds on which state shall not discriminate? Religion, race, caste, sex, place of birth. But in this case, it is religion, race, caste, and language. Right? So these are not the basis. Sex and birthplace are not the basis here. These are not the basis here. And what does it mean? It means that when it comes to admission to education institution, discrimination can be done on the basis of sex and birthplace. It means some education institutions may be restricted for women only, for men only, okay? And place of birth can also be a criteria, that from this particular region only we are going to allow people to have admission, right? So that's why these provisions were made, and these provisions were actually left when we talk about Article 29 subclause 2. I hope it is clear to you, right? Now, take into consideration this question. If you give attention to each statement which is mentioned here, your understanding of Article 29 will be jhingalala. That's my promise to you. Although answer is quite clear, but same statements can be used by UPSC in a different manner. UPSC can actually, what UPSC can do, UPSC can remove this statement, okay, and they will give these three statements and ask you which of the following statement is not true. This question is direct. This question is saying with respect to minority institutions, which of the following is correct, right? And first statement, the protection of Article 29 is available to Indian citizens only. So this is correct. This is the first sentence which I shared with you, that cultural educational rights are available only to citizens, culture, citizen, right? So this, when it comes to this question, answer is A. I'm saying if this question is reframed, okay, and now UPSC asks which of the following statements, okay, and you have no idea about these statements, right? Abhi to clear ho gaya ki theek hai, one is the answer. Now read the statements. A state cannot acquire the property of a minority educational institutions in any circumstance. What do you think? Means, can state acquire a madrasa or any religious education institution? What do you think? Is it true or false? Use your logic. So those who are thinking, no sir, we are a secular country, how can government do that? If government acquire a madrasa or any other religious education institution, it will create riots. It will be against the constitution. My friends, these kind of talks are apt for a politician. But you are here to get into civil services, right? So you have to be authentic and you should have clear-cut knowledge, okay? This particular statement is false because government can acquire a madrasa or any other religious institution, but there is a condition. Condition is adequate compensation need to be given so that their rights are not abridged, okay? So it means adequate compensation need to be given, and then yes, it can be acquired. So that with the compensation, the community, the people who are managing that religious institution, they can have some alternative mechanism in place. Okay. Now, third statement, the institution that neither seeks recognition nor aid from state is not a minority institution. Another beautiful statement. To have this understanding, first you should know what is a minority institution. how it is going to be categorized? So there are three categories of minority institutions. Three categories. What are these three categories? Let me show you quickly. Yeah. Minority education institutions are of three types. First, institutions that seek recognition. For example, recognition from a government board. Okay. Recognition as well as aid, means funds or some help from government. So this is one type of minority institution, having recognition as well as funds. Second, institutions that seek only recognition. पैसा नहीं चाहिए, पैसा बहुत है, right? They don't need money, they only need recognition, so that other students can actually trust that education institution and they can come and study there, right? So this will be considered as a minority institution also. Okay, just recognition and money both. Okay, so here you have R and A, means recognition and aid. Here you are talking about just recognition. Okay, and these two are actually categorized as minority institutions under Article 30. But there is a third criteria also. Who don't want, जो इन सब चीजों से ऊपर उठ चुके हैं, right? उन्हें ना तो recognition चाहिए ना aid चाहिए. They don't want recognition of government, they don't want aid from government, and yet they can be considered as minority institution. Okay, so institutions that neither seek recognition nor aid from the state, these are also minority institution, but they are not going to be defined as minority institution under Article 30. But since I am saying minority education institutions are of three types, so it means it is third type. Okay, but not as per Article 30. These details should be clear in your mind because UPSC is going to play on these points. Okay. Now, go back to the statement. The institution that neither seeks recognition, nahi chahiye recognition, aid nor aid from the state is not a minority institution. Don't you think that statement is false? Because it is a third type of minority institution, right? Now, a state cannot regulate the syllabus of such an institution if it is funded partially by the state. Kya mazak hai? If a state is going to fund you, then state is going to ensure the syllabus also. Okay? So here it is saying cannot means kar hi nahi sakte. That's not true. Cannot is not true. Okay? There may be a case that you only required aid and you did not require recognition. In that case, a state can say, since you are not recognized with us, but we have just funded you, okay, we are leaving you, decide your syllabus on your own. But if you are taking money and you are recognized, so there can be a possibility that you are taking money and as well as recognized. So in that case, you are saying that state cannot. How state cannot? State can regulate. Okay, so in these kind of questions, you should take a look that if UPSC is making a statement which is absolute in nature, cannot only, then you should be on red alert. Is there an exception which can happen? So there you can actually identify that statement is true or false. Okay, an understanding we are going to gain in this series, you need not to worry. Okay, now, so the explanation which I shared with you is explanation mentioned here. This PDF will be available in this Telegram group, Shashank Tyagi, for you. Okay, I'll share the detail in the last, so you can have this PDF there. Now, right of minorities to establish and administer educational institutions. This is Article 30. Please give attention. 2 words. Right of minorities, establish and administer. Okay, now bell should ring in your mind. Okay, it means now they're talking about minority institutions only, right? But in Article 29 subclause 2, we were using the word educational institutions. Okay, no discrimination in education institutions. Okay, but here the word minority institution, right? Right of minorities to establish, administer education institution is mentioned. Now, also known as Charter of Educational Right. Okay, so if UPSC says Article 29 is considered as Charter of Educational Right, that statement is false. Article 30 is considered as Charter of Education Right. Please remember that. These kind of factuals are also asked. Now, right to establish and administration education institutions of their choice. And when I'm saying of their choice, what does it mean? The choice word is also quite elaborate. Okay. So when I say choice, just choice include choice of how you are going to conduct the examination, how you are going to appoint the staff, how you are going to admit the students, how you are going to teach. It means, keep in mind that when I'm using the word minority institutions, you should not relate that minority institutions will only be there to provide education related to religion or a particular language. No. They can offer modern education, IT, engineering, and others also. For example, Jamia. Jamia is a best example of minority institution, right? So many type of courses are there. In granting aid, the state shall not. Now, in Article 30, our constitutional framers also actually added a protection layer to these minority institutions. Why? Because we have UGC at the center, University Grants Commission, whose purpose is to provide grants to these higher education institutions. Now, since minority institutions enjoy significant autonomy by virtue of Article 30, there can be a possibility, there could have been a possibility that UGC would say, oh, so you are the one who are going to enjoy your own autonomy. Other universities are working as per our directions, but you enjoy autonomy. Okay, so now we are going to give you less funds. So this minority institution would say, no, you cannot do this because Article 30 gives us this protection. Okay, so in granting aid, state shall not discriminate against any education institution managed by a minority. Okay, so you have many minority institutions. For example, you have Khalsa College in Delhi University, you have St. Stephen's College by virtue of a Christian society which opened it, right? Similarly, you have Mahavir Tirthankar University in Moradabad, right? So rights of minorities, whether religious or linguistic. So two type of minorities I've just told you. Now, I asked whether government can acquire a madrasa or any other religious institution. So you know the answer. Yes, it can be done. 44th Amendment Act 1978 to protect the right of minorities in this regard, the Amendment Act deleted the right to property as a fundamental right under Article 31. Now some of you might be thinking, why we are talking about 31 here? Because people were interpreting this education institution right of minority with property as well. So the compensation amount fixed by the state for the compulsory acquisition, means acquisition can happen, government can acquire, of any property of a minority education institution shall not restrict or abrogate the right guaranteed to them. So shall not restrict or abrogate the right guaranteed to them, it simply means that compensation should be enough so that they can have some alternative mechanism in place so that future of those students who were dependent or who were relying on this minority institution, that should not be compromised. This should be the priority. Okay. Now, Article 29 is about, means it is available to both minorities as well as majorities. I told you the interpretation made by Supreme Court about the language of 29 subclause 1, subclause 2, right? But Article 30 only to minorities or on the basis of religion and language, and these are available only to citizens. So both are available to citizens, but this is available only to minorities. Okay, so a statement can be made by UPSC on this particular differentiation. Please remember this. Okay, I have explained you the reason also. Okay. Now, so I have told you that three type of minority institutions, right? And these two types are under Article 30. Recognition, aid, Article 30. Only recognition, then Article 30, right? Now there are some guidelines related to minority institutions. So these guidelines were elaborated after Secretary Malankar's Syria Catholic College case in 2007. Now, so it summarized the general principles relating to establishment and management, and why this case actually came into being. Because the word establishment is quite clear. Okay, establish means you are starting. But when it comes to administration, so it is quite elaborate word because so many aspects are there in administration. Hiring faculties, having a criteria for admission, deciding the syllabus, paying the faculties, taking fees from students. So all of this comes under administration. Now the question was, if Article 30 should be interpreted in such a manner that this minority educational institution trust will decide faculty criteria on their own. For example, if someone you have to hire as a faculty to teach, say, engineering students. So common criteria is that person should at least have Masters in Technology, MTech. Okay? But if there is a minority institution, and can they make a criteria that for teaching BTech students, we can hire a person who is having diploma in engineering? Right? Do they have this kind of power, this kind of protection that government cannot do anything, whichever criteria of hiring faculties are made? What about fees? So can they charge on their own? What about passing marks? Can they actually make a criteria that for us 15%, if 100 out of 15 marks you gain, you will be deemed passed. So if they start giving degrees on this basis, don't you think it will be actually a harm to our overall education system? It will be harm to the future of those students as well. On what basis, on what standards you are maintaining for actually giving these degrees? So don't you think this is actually a valid question? How this word administration need to be elaborated? What kind of powers are there under administration, right? So that's why this was elaborated. Now, right of minorities to establish and administer education institutions of their choice means Article 30. So these are the choices. First is choose. It is governing body and manage the affairs. There will be a governing body of minority institutions and they will manage the affairs. Appointment, teaching staff and non-teaching staff, both will be there, and there will be some standards in place which they need to follow also. Admit eligible students of their choice and to set up a reasonable fee structure. Okay? Use its properties and assets for the benefit of the institution. It is not like, since it's a minority institution and now trust is actually one part of that particular property, now trust is using for personal purpose. Booking that property for banquets and cancelling the class, and now change the whole institution into a marriage hall and just some area are allowed for education institution. This kind of fraudulent activities cannot happen because this was clearly mentioned in Supreme Court guideline. Ensure equality with the majority. Now, this was another important development. Supreme Court said giving Article 30 is necessary, means for protection of the educational interest of these minorities. But it should be understood that ensure equality with majority not intended to actually place the minorities in more advantageous position. Means if minorities are given these rights, that they can establish their institution, right? So it should not be considered that they have this advantage but majority do not have this advantage. It should not be treated in this manner, okay? The general laws of the land relating to national interest, national security, social welfare, public order, morality, health, sanitation, taxation, etc. will be applicable to all. Even if you are a minority institution, but you have to adhere to these guidelines. Okay, you cannot consider that special preference are given. So that's why they will be you can say different from you can say application of these provisions. These are mandatory provisions, will equally apply to minority institution as they apply to majority institution. I hope now you are able to actually understand why this word ensure equality was used. Ensure equality in what context? In that context, in this context. Okay. Now, the right to establish and administer education is not absolute. It's not absolute. What does it mean? Consider there are 5 wealthy people belonging to a minority community and they apply that we want to start this minority institution. And if government is not allowing them, no, we are not going to allow you, we are not going to register your institution as minority institution. They cannot say, oh, this is wrong, we'll go to Supreme Court under Article 30. Even if you go to Supreme Court under Article 30, government will say that there is a guideline in place. For example, if guideline says if you want to establish a university for minorities, then you should have at least this much strength of staff, You should have this much financial capability. You should have these many labs in place. You should have this much land. So the basic criteria to establish an institution should be there. Then only you will be allowed to establish. You cannot say, if since I'm minority, I can start a university in my home. Now I'm converting my home into a university. You cannot do that. Okay? Nor does it include the right to maladministration. Means if you have privilege, but privilege cannot be considered as a maladministration. I'm going to run the administration on my own. No, you have to maintain the standards. The unaided minority education institutions who are not taking any aid, finances, will have the freedom to appoint teachers, lecturers by adopting any rational procedure. Please remember, my friends, the word rational procedure is mentioned. It means even if you are not taking any money from the government, okay, but if you appoint teachers who are not qualified enough, then it is like compromising the future of those students, and at that point of time government can intervene there. Okay, don't you think it is a necessary step, right? That's why regulation by government is a good step in that scenario. Now, the conditions can be imposed by the state to ensure proper utilization of the aid. Proper utilization of the aid means government will play on this intricacy. If you have got 1 crore rupees as a financial aid from the government, then it is not like your prerogative to actually spend it in your own manner. Let's organize a fest in this minority institution and we are going to bring some famous artist. You cannot do this in this manner, right? You have to be rational while you spend money, without, however, diluting and abridging their right. It means a balance will be maintained by the government. It is not like government is going to pinpoint on every step, but government will ask whether that money is actually being spent in a right manner or not. Okay. So this was Article 29, Article 30. I hope these details are clear to you. Now talking about Article 31. So Article 31 was repealed. Repealed means it was removed from our constitution, fundamental right part, and then it was added as Article 300A. Means it is a right mentioned in our constitution. But now you cannot knock the door of Supreme Court using Article 32 saying it is my fundamental right. Fundamental right status was taken. Okay. Now, so before this repealment happened, actually right to property was mentioned at 2 places in our fundamental right part 3. What were the 2 places? Article 19, subclause 1F. Okay. So what it said? It said everyone has the right to acquire, hold and dispose of property. Okay. Acquire means purchase, hold means to maintain, and dispose means to sell. So earlier this was a fundamental right given to you. Okay. Now, when I'm using the word property, what is coming into your mind? Most of the students think property means land. Sir is talking about land. But property is an elaborate term. There can be movable property, there can be movable property, right? So movable properties are also your properties, right? So you don't have that fundamental right now. Okay. Apart from this, Article 31 also mentioned about a right to property. No one can be deprived of their property. Okay, but after 44th Constitutional Amendment Act 1978, both of these provisions were repealed. Okay, means removed from part 3, and fundamental right now was given the status of constitutional right under Article 300A, because it is mentioned in Constitution. That is why we are using the word constitutional right. Okay, so you should keep in mind that if this fundamental right is taken, it is not like government will knock on your door tomorrow and government will say, since you don't have this fundamental right, now you have to empty your home within 24 hours because we are taking over this. And if you ask, sir, what we are going to get, then they will say, they cannot say that you are not going to get any penny. Okay, it means government can take your home for national importance, matter of national importance, but there will be suitable reason behind it. Okay. There should be suitable reasons, means arbitrary action will not happen. Okay. Now, so if government take this land, then government is going to compensate you. Government is going to provide money to you. Okay. What are the provisions for the compensation? That how much compensation will be given to you, on what basis? So now for compensation, we have two segments. For example, Article 30, property of minorities, they have their own compensation mechanism which is given due priority. It specifically mentioned that compensation should be such so that this right of them under Article 30 should not be compromised. As I told you, alternative mechanism they can settle so that future of those students who were actually relying on this institution, they should not be compromised. But when we talk about Article 31A, it is talking about a tool by which your property can be acquired by government, property within statutory limit. Now, what is the statutory limit? So, in some states, government started this land ceiling law. So, what is this land ceiling? Consider, you have one student, Rahul, okay? So, Rahul was having 100 bigha land. Bigha is a unit of land, okay, area. Now, UP government enacted a land ceiling in which under one name a person cannot have more than 70 bigha, okay. So, statutory limit means as per law made by Uttar Pradesh legislature, now the law says 70 bigha is the statutory limit. It means 30 bigha of your land will be taken by government. Now, how much compensation will be given to you? Now, just mention in comments how much compensation will be given to you if it is found you are having land above this statutory limit. How much compensation? Answer is 0. Mat baniye hero. You will be given 0 rupees. Okay? Because you are having this above statutory limit. Now, some of you might think, sir, why, how, on what basis government make these kind of laws? This is injustice with Rahul. We have solidarity with Rahul. Galat hua Rahul ke saath. The reason is, government want to bring social justice so that these 30 bigha or someone will be having say 120 bigha, so that person will be contributing 50 bigha. So, government will actually accumulate this and then government will redistribute it among landless farmers or landless people, weaker sections, so that we can have economic justice in society. So, this provision is a tool to do that. Okay. Now, so what happened with Rahul? Now, Rahul is having just 70 bigha because 30 bigha is gone to the government. Now, out of the 70 bigha, now government want to make a highway, and for highway 20 bigha land of Rahul is required. Now, when government acquired this 20 bigha, now tell me, this 70 bigha, it is above statutory limit or within statutory limit? Answer is within statutory limit. So, if government acquire your land within statutory limit, then government is going to compensate you. Government is going to compensate you. So, compensation will happen in this 20 bigha case, but compensation will not happen in this 30 bigha case because it was above statutory limit. Okay, I hope now it is clear to you. Now, take a look. Limit varies from state to state. For example, I gave UP 70. So, different states can have their own, you can say land ceiling. And is it mandatory that every state should declare statutory limit? No, it is not mandatory. It is prerogative of state as mentioned in Schedule 7 of our Constitution, state list, land being a subject of state. So, state can take away your land even when you are breaching the limit under the Article 31A, 31B, 31C. We are going to talk about these articles in detail now. Article 31A, 31B, 31C, exceptions to fundamental rights. You can call them exceptions to fundamental right. It means government wanted to justify their actions and without declaring their actions null and void. Because government was well aware what is there in Article 13. Article 13 says if there is a law which abridges these rights mentioned under Article 13, that law will be null and void, right? So, government wanted some protection, na? So, that is why they added these. Now, even if these articles violate Article 1419, Article 1419 fundamental right, one cannot go to Supreme Court because It is clearly mentioned in Article 31A, B and C that now this won't be considered as an abridgment of fundamental right. Now, I also want to tell you, here I am using the word 31A, means capital A. So it means it is a separate article, okay? And whenever you read articles in this manner, Article 19, subclause 1 or subclause A, so it means whenever small alphabet is used in these quotes, in these brackets, then it means this is part of, means this is within this article, okay? But when I am using 31A, so it means it is a different article altogether. Another example for you, take example of Article 21. So Article 21 is your right to life and personal liberty, right? So when we use this Article 21A, so can you say 21A is actually within Article 21? No. Article 21A is a separate article which was added by our Parliament through 86th Constitutional Amendment Act. So this is a separate article. So there can be an amendment where government add a particular article, okay? For example, recently we saw right to property was added. So right to property was added in 300A, capital A, a new article was added, okay? Although government can also do another kind of amendment. For example, if there is A, government can add B. For example, I discussed in Article 16, subclause 4, subclause 5 were added later, right? So subclause 4 means subclause, means we are adding in bracket. It means it is being added within that particular article. And why government do so? Because if the subclauses which government want to add are part or making the same sense as it is mentioned in Article 21, then government will add as a subclause. But if the sense is totally different, then government will add it as a separate article, okay? Now, so we have exceptions like to ensure social justice and economic equality, told you, that's why government can acquire this land. We have example like Zamindari Abolition Act, Land Ceiling Act. Zamindari was abolished, so when land was taken from the zamindar, do you think for every hectare of land which was taken, they were paid adequate compensation? No, because the statutory limit, means statute limit provision and specific provision that this land which you are having is with you due to the kind of land policy which was actually made by Britishers, and it is not conducive for the farmers of India, and that is why by law government took that particular, you can say the excessive land which was there, and so that it was redistributed later, right? So now 31A, what does it say? Just take a look at the kind of power government is getting. First, government can actually take, means acquire, estates. The word is estate, okay? Estate means property, land. Government can also take over management of property. It means it is possible that government is not acquiring you, can acquire. We have this power in subclause 1. Another is government is thinking, let's not acquire, but let's manage. So in that case, government will appoint certain officer that you will decide on how this property is going to be used. So government can do this if it is necessary for the nation, okay? For example, a particular ashram, is having, vast amount of lands in that particular area, and that the main person who was managing that died, and now there are a lot of conflicts happening on that property, and since it is a vast property and a lot of conflicts happening, in that case government can appoint a particular officer to manage that property till this dispute is resolved, okay? Amalgamation of corporations. It means, consider there are two companies. One company is quite weak, but a lot of people are working in that company. So if that company actually, you can say, go into the doom, then so many people will lose their job. So in that case, government can take action to amalgamate, to join this company with one strong company, so that jobs and prospects of growth for the other company can also be secured. And modifications of the right of directors of that corporation, what rights they have, the directors, because if they were not quite successful and they were having certain allegations for the protection of the future of the company and many people who were dependent on the company's future, government can take such action. Okay, and government has taken such actions. Look what Indira Gandhi ji was doing, right? We saw many private banks were actually nationalized, right? Amalgamation can happen or nationalization can also happen. Modification of the rights of mine owners, because mines were given on the lease, so in between the lease facility, the rights can also be altered by government using Article 31A. Okay, now cannot go to Supreme Court. You cannot go to Supreme Court if any of this thing happen with you. Okay, in the national interest. Article 14, Article 19, if they are violated under these provisions, you cannot go to Supreme Court. Okay. So expressively means clearly it is mentioned that if Article 14, 19 are violated, you cannot go to Supreme Court. Okay, you cannot say why only my company is amalgamated, why only my property is managed by government, why not others? This is against law. I'm not having equality before law, right? Why I'm not giving chance to present my case before court, before Supreme Court using, knocking the door of Supreme Court using Article 13. You cannot say that because Article 14, Article 19 are not available to you. Now, there's a beautiful, you can say, detail here. If I make a statement that if government acquire your property using the power in Article 31A, then you cannot go to court. You cannot go to court against such decision made by government. Tell me, the statement is true or false? Come on. So those who are saying, sir, this is true. Because just we have learned that government can acquire, and even if it is against 1419, you cannot go to Supreme Court. But my friends, in my statement, I have not used the word Supreme Court. I have used the word court. There's a difference between Supreme Court and court. The word Supreme Court was used here in Article 31A because now you are not having protection of these part as a fundamental right. But since you are having a right over your property, and if government acquire your property, you can go to local court. You can go to local court, but you cannot go to Supreme Court. You cannot say my fundamental right is abridged. And when you go to district court also, you cannot say my fundamental right is abridged, because they will actually analyze your case from the point of view that you have legal right over your property. Now court will assess whether there's a rationale behind such acquisition or not. Right? ऐसा तो नहीं है that the person who is a district magistrate who is acquiring this property, and this property belongs to some ex-girlfriend. Right? That movie you must have seen, na? मेरा इंतकाम देखेगी. अगर आप सोच रहे हो वैसा आप कर लेंगे, if you're thinking this can happen, मेरा इंतकाम देखेगी, then that person can go to court and court will ask you, you are district magistrate, but you cannot take arbitrary action. Give the rationale. Okay? So some things are fine in movie, but in reality, we have some layers of law in place. Right? So you have to use your mind when you exercise your power. Power is not the only thing. Now, Article 31B, laws enacted under 9th schedule. So, what is the story of 9th schedule? Government actually made a box, consider 9th schedule as a box, a protection box that government said that we are adding 9th schedule, and whatever law we are going to mention in 9th schedule, that will be beyond the judicial review or power exercised by Supreme Court using Article 13. It means we are adding a schedule, adding a list, list in the last of our constitution, 9th schedule, and whatever law, 1, 2, 3, no matter how many laws we add here, it means now these laws are getting some protection from Article 13. Okay? Now, so Constitution by First Amendment Act 1951. So it was done during the rule of Jawaharlal Nehru. Okay, he did this legal change, okay, constitutional change. Why? Because so that the sanctity of the laws which Nehruji was doing, enacting at that point of time, primarily land reforms. Because why it was necessary to add 9th schedule and to give protection over Article 13? Because my friends, till that point of time, this right to property was there in fundamental right? To make sure that the laws which are made by the government of the time are legally protected, and these should not be declared null and void. That is why this protection was added. Later, it was that this right to property was repealed. But earlier, this protection mechanism was made. Against principle of justice, government can misuse it. So these are some points here. Can insert unlimited laws into immune it. Means we are saying that adding the schedule 9 was having a lot of debate, that this can be misused against principle of justice, because if any law is added there, then you cannot actually have protection of review by Supreme Court, right? Can insert unlimited laws here because there was no limitation mentioned here. Now validity cannot be questioned. So that is why such action was actually questioned. Now, what happened? 13 laws in the beginning, and there were around 282 laws now. Okay. So now if I ask whether this ninth schedule still have that protection, that judicial review cannot be applied? No. We have this IR Coelho case, and this IR Coelho case, Supreme Court interpreted that violating fundamental rights, if this is happening, you can act. In this case, judicial review can happen. It means cannot go to Supreme Court under Article 32. This is what Schedule 9 was saying. But laws under 9th schedule after this date, means 24th April 1973, won't be immune. It means laws which were added by previous governments in 9th schedule, they will be immune. Means Supreme Court is not going to use judicial review power under Article 13 over those. Okay? उन पे नजर नहीं डालेगी Supreme Court. But those who are added later, as per our Coelho case, now we are going to use judicial review. Okay? So I think you will understand that this is a good initiative, right? Good interpretation. Misuse of 9th schedule could have been stopped. Now, Article 31C, the last part, introduction of 25th Constitutional Amendment Act. By this, Article 31C was added. So, this particular article was added to justify government action for actually applying or bringing a policy which is backed by DPSP. For example, our directive principle state policy have given this direction to the government. When you have enough capacity, political will is there, society is ready, then at this point of time you can make a law and provide these socio-economic rights which are mentioned in DPSP. Although they are not judicially enforceable, but it is a responsibility of government. But what happens sometimes when laws are made for giving these socio-economic rights, then they contravene with some of the fundamental right. Now, which should be regarded as superior, DPSP or fundamental right? So there's a beautiful debate here, right? So to save these laws, get into debate, 31C was added so that legitimacy of government action can be ascertained. Article 31 with a subheading right to property. So this has 44th Amendment Act. This was removed and it was added in 300A. Now, what it says, any law by Parliament, state legislature in order to enforce 39B, 39C, we are talking about DPSP, violating 1419 will not be void. Okay, so it means if government is making, means state legislature, parliament are making law for enforcing DPSPs mentioned in 39B, 39C, and even if they violate 14 and 19, then also it will not be considered as violation, it will not be considered as void. Okay, equal distribution of resources, 39B, 39C says no concentration of wealth. I hope now you can connect why 31C was added, because 39B saying equal distribution of resources, 39C saying no concentration of wealth. So if you have too much wealth, so there is nothing like too much when it comes to wealth according to some people. But the point is, other people are having so much poverty, inequality is there, inequality is going to create instability. So government may take some part of your wealth by having such law. So at that point of time, you cannot knock the door of Supreme Court, sir, just declare this null and void. Why? Because 31C is giving protection to this law made by government. Because government will say, sir, DPSP gave us information, DPSP gave us the direction, we just simply actually followed what was the ideal given by constitutional framers. So even if it abridged 1914, then also this will not be considered as void. I hope this discussion is clear to you and this discussion added some value in your preparation. For this PDF, you can reach out to me in Telegram group Shashank Tyagi for you. You can also send me message on Insta or Twitter wherever you have doubt. I'll be more than happy to help you out. See you.